Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Starting with the controversy around the movie The Kerala Story. You must have already seen the trailer by now. The film claims to be based on true events that took place in the state of Kerala, where Hindu and Christian girls were trapped in love jihad and converted to Islam and sent on missions to Syria, Iraq and Afghanistan on behalf of ISIS. The movie is about the journey of 4 college-going females from Kerala who end up joining the Islamic State. Regarding this, an interlocutory application was filed in the Supreme Court in an already pending writ petition seeking action against hate speech crimes. The Supreme Court today expressed disinclination to consider an interlocutory application challenging the release of the movie. A bench comprising Justices K.M. Joseph and B.V. Nagaratna observed that challenging the release of a movie through an interlocutory application is not an appropriate remedy. The bench said that once a movie has been certified by the Central Board of Film Certification, the courts cannot interfere unless the certification is challenged in a substantive petition. Another update on the same issue is that a petition has been filed before the Kerala High Court by the office bearer of an NGO named Rajiv Gandhi Study Circle. The petitioner has sought for a stay on release and removal of all incorrect and unverified statements and scenes derogatory to the Muslim community and to the state of Kerala from the film. The Kerala High Court today sought the response of the centre and the producers of the film on the petition. A division bench comprising Justice N. Nagesh and Justice Muhammad C.P. posted the matter for further consideration on 5th May. The third update on this issue is that Islamic clerics organization Jamaat Ulema-e-Hind has also moved the Supreme Court seeking to ban the screening or release of the movie The Kerala Story at theatres, OTT platforms and other such avenues on the ground that the movie is likely to cause hatred and enmity between different sections of society in India. Also, let me tell you here that amid this controversy may be threatened with legal action, the filmmakers have changed the description of the teaser on YouTube to the true story of 3 girls from the earlier number of 32,000 girls. For more updates on the controversy, stay tuned with Livelaw. The Supreme Court today dismissed the special petition filed by Delhi Police challenging the bail granted by the Delhi High Court to student activists Devangana Kalita, Natasha Narwal and Asif Iqbal Tanha in the Delhi riots larger conspiracy case. As you already know, the Delhi police had filed a charge sheet against them alleging that the protests organized by them against the Citizenship Amendment Act from December 2019 were part of a larger conspiracy behind the communal riots which took place in the last week of February 2020 in northeast Delhi. The bench comprising Justice Sanjay Kishan Kaul and Justice Asanuddin Amanullah said that there was no reason to keep this matter alive as the accused have been on bail for nearly 2 years. Also, when Delhi High Court had granted bail to the student activists, the court had given an extremely elaborate order on bail interpreting provisions of the UAPA Act. Solicitor General of India Tushar Mehta, appearing for the Delhi police, made a strong persuasion before the Supreme Court bench to specifically clarify that the High Court's order should not be treated as a precedent. On this, the bench clarified that it has not gone into the correctness of the interpretation given by the Delhi High Court to the provisions of the UAPA, and so the Delhi High Court's order should not be used as a precedent. And now coming to an update on the Bilkis Bano case. The final hearing in Bilkis Bano's case today could not take place in the Supreme Court as scheduled after lawyers appearing for some of the convicts raised disputes on Bano's affidavit regarding service of notice. Bano has approached the Supreme Court challenging the decision of the Gujarat government to allow the premature release of convicts who were sentenced to life for gang rapes and murders during the 2002 Gujarat riots. Although a bench comprising Justices K.M. Joseph and B.V. Nagratna had posted the matter for final hearing today at 2 p.m., no effective hearing happened. According to the affidavit filed by Bilkis Bano, as some respondents had refused notice, so deemed service of notice should be declared. But advocates appearing for some convicts took objection to this, saying that according to the postal records, service could not be completed as the parties were out of station. Now the bench had to adjourn the hearing in order to give time to them to file a counter affidavit to bring their objection on record. Another difficulty was, as service was not complete on all respondents, so the bench directed completion of service on the unserved respondents. Since Justice Joseph is set to retire on June 16th and May 19th is his last working day before the vacations, he offered to sit during the vacations to hear the matter. Though the petitioners were ready, but Solicitor General Tushar Mehta and the respondent lawyers were not willing. Justice Joseph expressed his anguish at the hearing getting delayed on procedural grounds and said that it was obvious that the respondents did not want the bench to hear the matter. Ultimately, the bench decided to adjourn the hearing till July and to list the case after 2 weeks to ascertain the completion of service. The Supreme Court today appointed its former judge, Justice L. Nageswara Rao, to take over the process of considering the draft constitution of the All India Football Federation AIFF, along with all suggestions, comments and objections made by the stakeholders to the said constitution. A bench comprising CJI D.Y. Chandrachud and Justice J.B. Pardiwala directed for a comprehensive report on the consideration of the draft constitution to be carried out by 15th July 2023. These proceedings can be traced back to the 2017 order of the Delhi High Court, through which it had set aside the election of office bearers of the AIFF. This order was passed in a petition filed by sports activist advocate Rahul Mehra, who had contended that the elections for office bearers violated the National Sports Code. After this, the Supreme Court constituted a 3-member committee of administrators to facilitate the holding of elections and handing over the affairs to democratically elected body. In another important update, the central government today informed the Supreme Court that it was considering forming an expert committee to determine if the execution of death penalty by hanging was proportionate or not, and if there were other better suited alternatives for executing the death penalty. A bench comprising Chief Justice D.Y. Chandrachud and Justice J.B. Pardiwala was hearing a PIL seeking to abolish the present practice of executing a death row convict by hanging, which involves prolonged pain and suffering, and to replace it with intravenous lethal injection, shooting, electrocution, or gas chamber in which a convict could die in just a matter of minutes. In the last hearing, the Supreme Court had pondered about forming an expert committee and had asked the Attorney General R. Venkataramani to find out data on the impact of death by hanging. Today, the Attorney General informed the bench that he had recommended the formation of an expert committee to decide upon whether there existed better alternatives to execute the death penalty. Taking the submission of the Attorney General into account, CJI D.Y. Chandrachud listed the matter for hearing after vacations in July. And lastly, coming to the update from Gujarat High Court on the plea filed by Congress leader and disqualified MP Rahul Gandhi. The Gujarat High Court today reserved its order in the criminal revision plea filed seeking a stay on Gandhi's conviction in the Modi thieves remark case. The bench of Justice Hemant Prachak also refused to grant any interim protection to Rahul Gandhi. Before the court, senior advocate Nanavati appeared for the complainant Purnesh Modi and contended that Gandhi was not disqualified by court or by the complainant, but by the operation of a law made by the parliament, and so he could not argue that he is suffering an irreversible loss. He further submitted that Gandhi had shown no remorse for his defamatory statements. On the other hand, senior advocate Abhishek Manu Singhvi, appearing for Rahul Gandhi, strongly argued that the alleged offence did not involve the element of moral turpitude. It was a non-cognizable, bailable and non-serious offence, and therefore the conviction should be suspended. Having heard the arguments of both sides, the court reserved its verdict. The decision on whether a stay will be granted on the conviction will be delivered by the bench post-court vacations. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can check the links given in the description box. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.